Did you know that South African law gives communities preference to mine on land connected to them, but only if very specific conditions are met? Today's SA Mining Desk episode, we unpack preferent prospecting and mining rights under Section 104 of the MPRDA. We will look into who qualifies, how the application process works, why notice, awareness, and timing are critical, and how recent amendments have changed the real impact of this transformation tool. Hi everyone, and welcome to SA Mining Desk, your partner in navigating the South African mining sector. Thank you for joining us today. Please remember to like, comment, and follow the channel. Let us begin. What is a preferent prospecting or mining right? A preferent mining right application is an application for a mining right or a prospecting right lodged together with an application for preference to be granted that right over any other application for the same mineral and land. This is done in terms of Section 104 of the Mineral and Petroleum Resources Development Act, MPRDA. These applications are lodged by a community which wishes to prospect or mine minerals on land that is registered or in the process of being registered in the community's name. For ease of discussion, we will use the term preferent mining right to refer to both preference prospecting and preferent mining rights, unless stated otherwise. Purpose of a preferent mining right. A preferent mining right is one of the tools used by the MPRDA to transform the mining sector. Its purpose is to promote equitable access to mineral resources and to expand opportunities for historically disadvantaged persons, or HDPs. The MPRDA does this by giving communities preference to be granted mining rights over land that is connected to them. The Constitutional Court explained this transformation objective in the Agri-SA case, where it noted that apartheid laws placed about 87% of land and mineral resources in the hands of only 13% of the population. As a result, white South Africans held most economic power, while the majority of black South Africans were excluded from benefiting from mineral resources due to landlessness, exclusion, and poverty. To address this deep economic inequality, legislative measures were introduced to promote equitable access to the mining industry. One such measure is the MPRDA. Who can apply for a preferent prospecting or mining right? There are three main requirements a community must meet to apply for a preferent mining right. The applicant must be a community. The MPRDA defines a community as a group of historically disadvantaged persons who have an interest in or rights to a specific area of land. These rights are exercised communally and may arise from custom, agreement, or law. The applicant must qualify as an HDP. An HDP includes any natural or juristic person, category of persons, or community that was disadvantaged by unfair discrimination before the Constitution came into effect. The land must be registered or to be registered in the name of the community. The land in respect of which the preferent right is sought must fall into one of the following categories: land that is registered or in the process of being registered in the name of the community. This means either the title is already in the community's name or registration is still underway. Land that has been restored or is to be restored to the community under the Restitution of Land Rights Act 1994, read with Section 25(7) of the Constitution. Land that is the subject of a successful land restitution claim, even if it has not yet been formally registered in the community's name. Communal land currently registered in the name of the state or a state entity as trustee. In the case of Bengwenyama-ya-Maswazi community versus Genorah Resources on September 26, 2014, the Supreme Court of Appeal confirmed that a community pursuing restitution may qualify for a preferent prospecting right before formal registration, provided there is a strong probability that the land will be registered in the community's name. How is the application lodged? The community must lodge 3 applications simultaneously. A mining right application in terms of Section 22 of the MPRDA, an application for environmental authorization. The preferent mining right does not exempt the community from environmental requirements. In full compliance with NEMA remains mandatory. An application for a preferent mining right in terms of Section 104 of the MPRDA. The application then follows the 6-phase mining right application process, as discussed in our previous video. However, there are a few important points to note. Required application documents. The community must prepare all required mining right application documents and pay the prescribed application fee. All the requirements for an ordinary Section 22 mining right or Section 16 prospecting right must be met. This includes documents such as the Regulation 2.2 plan in the Mining or Prospecting Work Program. While not specifically required, it is advisable for the community to include a letter clearly stating that it is applying for a preferent mining right, together with background information about the community, its connection to the land, and supporting documents. In addition, the community must submit a developmental plan. This plan must explain how the right will be used to contribute to the development and social upliftment of the community. Although not exhaustively defined, this may include mine community development projects, human resource development, housing conditions, and supplier and enterprise development. How the preferent right will be exercised by the community as a community. This relates to the structures the community will use, such as a trust, traditional council, corporate vehicle, or agreements in exercising the right. How the benefits will accrue to the community, including how profits and losses will ultimately be shared amongst the community. On the use of corporate vehicles, the Supreme Court of Appeal in Bengwenyama-ya-Maswazi Community versus Minister for Mineral Resources confirmed that communities may partner with corporate entities to access technical or financial resources and may use corporate vehicles. However, the community must retain sufficient control and ensure that benefits accrue to them, as required by Section 104 of the MPRDA. These considerations are not merely practical suggestions. Section 104, subsection 2 of the MPRDA expressly requires that the preferent mining right must be exercised for the benefit of the community. Importantly, the community is not required to submit a social and labor plan, nor to separately demonstrate that the right will expand opportunities for HDPs. Existing rights and preferent mining rights. A preferent prospecting or mining right cannot be granted over land where there is already an existing right or permit, regardless of the mineral involved. This is a strict legal limitation, and the department has no discretion to grant a preferent right where an existing right or permit is already in place. Prior accepted applications and preferent rights. The preference enjoyed by communities applies mainly in relation to pending applications. Where land is registered or to be registered in the community's name, the department has a positive duty to inform the community of any other application over the land, give the community an opportunity to lodge a preferent application, allow the community to make representations where appropriate. If a non-community application is received, the department must inform the community of that application and explain its consequences for the community's preferent right. Importantly, a prior accepted application does not prevent a community from lodging a preferent prospecting or mining right application. Equally important is to understand that a preferent mining right does not guarantee that the right will be granted. The preference applies only in relation to other applications for the same land and mineral. The final decision remains discretionary and subject to compliance with the requirements of the MPRDA. Granting of a preferent mining right. A preferent mining right may be granted if the general requirements for granting a mining right are met. The main exceptions relate to social and labor plans and expanding opportunities to HDPs, as already discussed. The department will also evaluate the developmental plans submitted by the community. Duration of the preferent right. A preferent right is granted for a period of 5 years and may be renewed for a further 5-year period. Preferent mining right versus ordinary mining right. What is the difference for communities? For communities, choosing between a preferent mining right and an ordinary mining right has important practical implications. A preferent mining right offers a clear advantage because it gives the community priority over other applicants for the same land and minerals, recognizing the community's historical connection to the land and supporting transformation objectives under the MPRDA. It also removes the need for a social and labor plan, which can reduce compliance costs and administrative complexity. However, this process is more restrictive as it can only be used where the land is registered or to be registered in the community's name, and it cannot be granted if any existing right or permit already exists over the land. An ordinary mining right, on the other hand, is more flexible and can be applied for by communities even where land ownership is not formalized, but it offers no preferential status over competing applicants and requires full compliance with social and labor plan obligations. In practice, a preferent mining right is most beneficial where there are pending applications on the community land, while an ordinary mining right where there are not competing applications. Effectiveness of the preferent mining right as a transformation tool. For a community to exercise this right effectively, the community must first be aware that the right exists. The responsibility to ensure such awareness rests with the department. If a community is not informed of competing applications over its land and its impact on the preferent right cannot be exercised in any meaningful way. This process was firmly established in Bengwenyama Minerals Proprietary Limited and others versus Genorah Resources, where the Constitutional Court held that the department breached the community's right to procedural fairness by failing to notify it of a third-party application and its adverse consequences for the community's ability to apply for a preferent prospecting right under Section 104. The court made it clear that the community should have been given a real opportunity to bring a Section 104 application before a decision was taken on the competing application. The granting of a preferent mining right is expressly linked to compliance with the general granting criteria set out in Section 23 of the MPRDA. This constrains the practical value of the preferent right, as communities are placed on the same footing as ordinary mining right applicants, without meaningful opportunity to organize themselves. The requirement that land must be registered or to be registered in the name of the community fails to consider that the majority of South Africans hold land rights outside the formal deeds registry system. Moreover, it is in sharp contrast to the definition of community in the MPRDA, which recognizes informal land rights. Although there are constraints to the effectiveness of this tool, the preference over any other application on land connected to the community remains one benefit that cannot be downplayed. This preference, provided the conditions are met, places the community at an advantage concerning minerals that are on their land. This the community may use to negotiate commercial transactions with companies seeking to mine in their area should they be willing to do so. But the question becomes, are communities who have land registered or to be registered in their name aware or made aware of this transformation tool? What is your answer to this question? We would love to hear from you. Before we close, here are a few key takeaways on Section 104, Preferent Mining Right. To apply, you must be a community that falls within a category of Historically Disadvantaged Person, HDP, and must have land registered, in process of registration, or restored or to be restored to the community. In applying for preferential right, you must also apply for a mining right or prospecting right and environmental authorization. The community must demonstrate through a developmental plan how benefits will accrue to the community, how the right will be exercised, and how the right will be used to contribute to the development and social upliftment of the community. Preferability relates to other pending applications and is subject to approval. The DMPR has a positive duty to inform the community of any application on its land and the impact of that application on the preferential right. Proper exercise of this right is dependent of community awareness, engagements, and compliance. The community should be given a real opportunity to bring a Section 104 application before a decision is taken on the competing application. Preferability is not applicable where there is already an existing right, regardless of the mineral concerned. Granting of preferential right is linked to compliance to general criteria of granting a prospecting right or mining right. Communities must retain control over the right, even with corporate partners.
And that brings us to the end of today's discussion. In your own view, do you think Section 104 application is effective or achieves the purpose of its existence? We would love to hear your thoughts on the subject. Thank you for spending your time with us. If you found this video helpful, please like, comment, and subscribe to the channel. Please know that you are valued and appreciated by us. Until next time, take care.